A discussion about the Kaufman case and what is or is not so-called cognizable legislative history documents. The key case to discuss the use of legislative history and intent materials provides some clear guidance in that decision. The appellate court issued its written decision August 30th of 2005. And since that time, it's been cited affirmatively more than 90 times by California appellate courts. The case is called Kaufman and Broad Communities versus Performance Plastering. Again, from 2005, the citation is 33 Cal Reporter 3rd, page 362. And this written decision was issued by the 3rd District Court of Appeal located here in Sacramento, California. And it basically involved an opinion ruling on a motion for judicial notice of legislative history documents. It was a 3-2 decision, and the appellate court set forth a listing of legislative history and intent documents that are cognizable or acceptable, as well as those that do not constitute cognizable legislative history. Now, as you probably are aware, there are numerous sources to help determine the legislative history and intent of a bill's provisions, and this the court, of course, affirmed. The California Rules of Court basically allow a party to seek a court to take judicial notice of certain documents that constitute legislative history. So in this case, Performance Plastering sought the court to accept legislative history of a 1998 amendment that was made to California's Revenue and Taxation Code, specifically 19719, which was added in 1998 by then Assembly Bill 1950. And the Kaufman Appellate Court said that in order that legislative intent be given effect, that a statute should be construed within the ordinary meaning of the language used and be in harmony with the whole system of law. They said that a wide variety of factors may illuminate legislative design, such as the context, the object in view, the evils to be remedied, the history of the times, other legislation of the same topic, public policy, and even contemporaneous construction of the statute. In the Kaufman case, the court first discussed legislative history in broad general terms, and the court began by criticizing what they called many attorneys and some professional legislative intent services companies for their expansive view of legislative process papers that should be properly subject to judicial notice. In fact, the appeals court told practitioners that the lack of justification for each request for judicial notice must stop going forward. And there the court went on to describe that the purpose of their opinion is to help attorneys to better understand the role of legislative history and to encourage attorneys to request judicial notice only of documents that actually constitute cognizable legislative history. So how should those seeking to determine legislative intent proceed? The first thing is you have to review the introduced bill and thereafter look at the amended versions of the bill and of course the final bill language that was chaptered into law. The purpose of doing this is to understand the different changes that were made to the bill language through the legislative process, particularly which words or phrases were included or excluded. Then courts also try to identify the broad policy framework and the statutory scheme within which to analyze any individual section, word, phrase, or even a clause. Courts look to ascertain whether the legislative history documents in particular are relevant and whether their source is reliable so that the court should and can and will accept the document as indicative of intent of the legislature. What the appellate court did in the Kaufman case was basically to create two categories of legislative history documents. And the court, the appeals court, the Third District Court of Appeal again, specifically listed what it deemed to be cognizable legislative history and then determined that which is not cognizable legislative history. And the appellate court distinguished between the two on the basis that cognizable legislative history is that which must shed light on the collegial view of the legislature as a whole. That's the key phrase there. In December of 2005, the California Supreme Court was actually asked to overturn and depublish the Kaufman decision, but the High Court declined to do so, and therefore it is still good law in California. So, what is cognizable as a legislative document? Pursuant to the Kaufman decision, the following are documents that constitute cognizable legislative history in the Court of Appeal for the Third DCA in the cases that the court cited. Ballot pamphlets, including summaries and arguments in the statement of the vote, committee files, conference committee reports, different versions of the bill, floor statements, House journals and final histories, reports of the legislative analyst, legislative committee reports and analyses, Legislative Council's digests, Legislative Council's opinions or supplemental reports, Legislative Party floor commentaries, official commission reports and comments, predecessor bills, statements by sponsors, proponents, and opponents, transcripts of committee hearings, and analyses by legislative party caucuses. So, what did the third DCA and the Kaufman decision say were non cognizable legislative documents? Well, under the Kaufman decision, the following are some of the documents that they said do not constitute cognizable legislative history in the Court of Appeal for the Third DCA. Authoring legislators' files, letters, press releases, and statements that are not communicated to the legislature as a whole. Documents with unknown author and purpose. Enrolled bill reports prepared by the executive branch of government. Handwritten document copies without author noted, letter from a consultant to the state bar tax section to the governor, letter from the family law section of the state bar to an assembly member or senator, letters to the governor urging the signing of a bill, letters to particular legislators, including the bill's author, magazine articles, a memorandum from a deputy DA to proponents of an assembly bill, proposed assembly bill which was withdrawn by the author, the state bar's view of the meaning of proposed legislation, subjective intent that's reflected by statements of interested parties and individual legislators, including the bill's author, that have not been communicated to the legislature as a whole, and views of individual legislators, staff, and other interested parties in the legislative process.